Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to Phase 2 of Conquer Prelims 2024. In Phase 1, which is going on our platform on Unacademy app, the focus will be on the static portion of the Prelims syllabus. On YouTube, the first lecture is today. We will cover current affairs, subject-wise, of the past 18 months. Polity-based current affairs, international relations-based current affairs, science and technology, environment and ecology-based current affairs, economics-based current affairs, so on and so forth. But I would urge all of you to attend these sessions live, because as you can notice, the live chat has been enabled for the first time, which is for you to be encouraged in asking your questions, doubts, queries regarding these current affairs topics that we shall be discussing today. But please keep the live chat civil. Don't indulge in hate or unnecessary spamming. Otherwise, we will have to disable the live chat as we do it. That's number one. Number two, this course, Conquer Prelims Phase 2, which covers current affairs for the past 18 months, is not free. You have to pay for it in the form of your likes, comments, subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. We shall be discussing lots and lots of MCQs, but I will also be preparing and presenting before you the concepts or additional information related to these MCQs. For example, if we are discussing 15 MCQs, but we will discuss concepts, much more concepts than those 15 questions, so that you can be satisfied that we are covering close to 45 MCQs. Because the MCQs that I have prepared may not necessarily be directly asked in the examination, but concepts related to those MCQs may be asked, and that will become important for you in your upcoming prelims examination. So let's get started. And first up, a very, very important announcement, which I consider is very important for all those aspirants attempting exam in 2025 or beyond. 15 months of subscription, which used to be in excess of 70,000, the course fee has been reduced to under 25,000. And I can tell you, this course fee will not remain the same for the entire year. We will never revert to this price. So those of you who are considering online coaching in English medium, if you want, should you wish to enroll in this program, please consider during this, what we call offer period, because this price is not going to come, unfortunately, again. So let's get started. We will display a set of questions. You can answer those questions as well. I will give you 1 minute to answer these questions, and then we will conduct a detailed explanation of those concepts. First up, question number 1. Which of the following statements regarding the Chief Election Commissioner and other election commissioners' appointment, conditions of service, and term of office Act 2023 is or are incorrect? Number 1. The CEC and the election commissioners shall be appointed by the President upon the recommendation of a selection committee consisting of Prime Minister, the Union Home Minister, the Leader of Opposition, or the Leader of the single largest party in Lok Sabha. So you read these statements and let me know what is the right answer. So you have got 1 minute to respond to this question. Please read the questions carefully, read the statements carefully. Constitution says, under Article 324 of the Constitution, it creates a constitutional body called Election Commission of India. And Constitution says superintendence, direction, conduct and control of all elections, whether it is Lok Sabha elections, Rajya Sabha elections, Legislative Assembly elections, Legislative Council elections, President or Vice Presidential election. The responsibility of ensuring these elections is with this constitutional body called Election Commission of India. And Constitution says ECI shall consist of Chief Election Commissioner and as many election commissioners as may be appointed by the President. But Constitution further said this will be subject to the law passed by the Parliament. Till about 1989, we only had a chief election commissioner, then 2 more election commissioners were appointed, but in 1990 they were removed. Then the law was passed in the year 1991, and it is this law which provided for appointment of election commissioners as well. And according to this law, which was amended in 1993, we can have a chief election commissioner and at best 4 election commissioners. And all of them shall be appointed by the President. The decision of the Election Commission of India should be ideally taken by unanimity. There has to be a unanimous decision. If not, the decision shall be taken by a majority vote. But all these election commissioners and chief election commissioner was appointed by the President in consultation with the Prime Minister, which means the ultimate control over these appointments rested with the executive. Then in 2015, a petition was filed in the Supreme Court by Anoop Baranwal, and finally in 2023, the verdict was given by the Supreme Court. And Supreme Court said, to ensure free and fair elections, the Chief Election Commissioner and the Election Commissioner shall be appointed by the President after consulting a committee consisting of Prime Minister, Leader of the Opposition in Lok Sabha, and the Chief Justice of India. But this Supreme Court said is subject to the law passed by the Parliament. That means this will not remain forever. This committee consisting of Prime Minister, Leader of the Opposition in the Lok Sabha, or the Leader of the single largest party in Lok Sabha, and the Chief Justice of India will recommend to the President who should be appointed as Chief Election Commissioner and Election Commissioners, but this is subject to the law passed by the Parliament. And then finally, this law was passed by the Parliament. Now listen to me carefully. This law, which was passed in 2023, has repealed the 1991 Act. But that 1991 Act did not speak about appointment. That 1991 Act, it spoke of conditions of service, terms of office. For example, Chief Election Commissioner shall be appointed till the age of 65 or 6 years, whichever is earlier. Election Commissioner cannot be reappointed as Election Commissioner, but Election Commissioner can be appointed as the Chief Election Commissioner, so that the combined term of Chief Election Commissioner and the Election Commissioner shall not be more than 6 years combined. But listen to me carefully, this can be an important statement because the court said in Anoop Baranwal judgment that there is a lacuna because the law has not been passed. Law should have been passed to regulate the appointment of Chief Election Commissioner and the Election Commissioners. But now you must be wondering, sir, there was a law in 1991 which was amended in 1993, but that law only spoke of conditions of service, term of office. It did not deal with the appointment. And this law, it talks about that there should be a committee consisting up of Prime Minister, Union Minister nominated by the Prime Minister. So it is not the Union Home Minister. It is a Union Cabinet Minister nominated by the Prime Minister. Can be a Defense Minister as well, can be a Finance Minister as well, can be an External Affairs Minister as well. That is why this particular statement is incorrect. But how will this committee recommend to the President who should be the Chief Election Commissioner, who should be the Election Commissioners? For that, there has to be a search committee. This search committee will have to be constituted, which will be led by whom? Not the Cabinet Secretary. It will be led by the Union Minister for Law. And this Union Minister for Law will lead this search committee, and they will propose 5 names to this selection committee, consisting up of Prime Minister, Leader of the Opposition, and the nominated minister by the Prime Minister. But it is not necessary for the selection committee to only consider those names recommended by the search committee. No, they can go beyond that as well. That means they can appoint somebody who has not been considered by this search committee, which cannot consider any other person. So this statement is also incorrect. Cabinet Secretary is also incorrect. So statement number 2 also becomes incorrect. Then statement number 3. This act repealed the Act of 1991. This is correct. The 1991 law passed by the Parliament, which only spoke about term of office, conditions of service, that has been replaced by this 2023 law. Statement number 4. Both the acts, 1991 and 2023, dealt with the appointment, salary and conditions of service of the Chief Election Commissioner and Election Commissioners. This statement is incorrect. Why? Because 1991 law did not deal with the appointment. The question is asking which of these statements are incorrect. So C, 3 statements are incorrect. That is the right answer. Is that clear? Only 1 statement is correct, but the question is asking which of these statements are incorrect. That is why you have to be absolutely sure. What is the question asking? What is the demand of the question? What is the requirement of the question? The question is asking which of these statements are incorrect. Clear? Great. Let's look at question number 2. Who are the absentee voters under the Conduct of Election Rules 1961? You have got 1 minute. Please answer this question. A person who is employed in essential services, senior citizens, persons with disability, COVID-19 suspect or affected persons, non-resident Indians. Select the correct code from below. Tell me what is the right answer. Read the question carefully. Let me know what is the right answer. The correct answer is C, 4. Now, who are these absentee voters? According to the Conduct of Election Rules, there is Rule 27 capital A. This Rule 27 capital A, which speaks about absentee voters, that means these absentee voters, they are entitled to vote through postal ballot, for example, recently in Lok Sabha elections in Karnataka, there were lakhs and lakhs of senior citizens who opted for this provision of vote from home. So there is something called work from home, and there is something called vote from home as well, which means the election notification has been issued. Within 5 days of the election notification, if I am an absentee voter, under Rule 27 capital A of the Election Conduct Rules, form the Assistant Returning Officer, that I cannot be present at the voting station at the polling booth. So you have to send somebody to my home and to register my vote. And then people will come, officials will come along with the videographer to ensure that secrecy of the vote is not violated, to ensure that this is a fair vote. In 2020 Bihar Legislative Assembly elections, the Election Commission of India allowed those who were COVID suspect, who were COVID affected, senior citizens above the age of 80 to vote from home. And now for the ongoing Lok Sabha elections, all the senior citizens above the age of 85, they can opt for this absentee voter, that means postal ballot. Who are the others who can vote remotely, through postal ballot? Yes, a person who is employed in essential services, senior citizens as well, persons with disability, and the percentage of disability should be 40% or more. For Lok Sabha elections, 85 years or above. COVID-19 suspect or affected persons, but non-resident Indians, they are not declared as absentee voters. That means for them, they are not entitled for postal ballot. So the right answer to this question is C4 is the right answer. Clear? Perfect. Let's look at question number 3. Which of the following statements regarding systematic voters' education and electoral participation, SVEEP, is or are correct? You have 1 minute to answer this question. Mehul is asking an interesting question. Sir, not all senior citizens are entitled to vote through postal ballot. That is why the statement does not refer to all. If I would have mentioned all senior citizens, then this would not have been the correct option. I'm only mentioning senior citizens. And persons above the age of 85, are they not senior citizens? They are. These qualifiers, all, only, most, this becomes very important for you to understand. Question number 3, let me know what is the right answer. And I encourage all of you to participate. You will receive the PPT, yes. A program was launched by the Election Commission of India in the year 2009. What was this program all about? That we need to ensure voter education. We need to educate voters, encourage them to participate in the elections. And then, through this voter education and awareness, we should drive the voter turnout as well. This initiative was launched by the Election Commission of India in 2009. And very next year, in 2010, this initiative was given a name called SVEEP, Systematic Voters Education and Electoral Participation. Because we have seen the participation of voters in the election is going down. Now, whether that is because of the heat wave in different parts of the country, or whether generally in urban areas there is voters' apathy. They don't want to come out in large numbers and vote for the candidates of their choice. But a campaign was launched in 2009, and SVEEP was born in the year 2010. And the objective of the SVEEP is, we need to ensure that voters first register. We need to encourage voters' registration, and then we should drive voter turnout. So the focus of SVEEP is only on voter registration and not on increasing the voter turnout. This is incorrect, because the focus is on both voter registration as well and increasing the voter turnout as well. For example, the purpose, one of the objectives of SVEEP is we should encourage that in 2024 Lok Sabha elections, the voter turnout should be 75%. These facts can be very important for your prelims examination. That is the objective of SVEEP, to ensure that in 2024 Lok Sabha elections, the voter turnout is 75% or above. So the objective of SVEEP is increase voter registration as well as increasing the voter turnout. The objective of sweep is to purify the electoral roll of every polling booth. This is correct. Purification of the electoral roll means those who are dead, we need to remove them. Those who are shifted, we need to remove them. For example, my vote was in constituency A, but now I have shifted to another state and I have registered as a voter in that state after some time. So I have shifted from one electoral roll to another. That is something that we have to purify. Similarly, repeat entries. I may be registered voter at multiple places. This is what we call purification of the electoral roll. And the purpose of sweep is not only on voters' education or voters' participation or focused on voter turnout, it is also on increasing or purifying the electoral roll of every polling booth. And I've told you that although this idea that we should encourage voters' education that started in 2009, but sweep was born in 2010. So it was implemented in its present form in the year 2020. And the question is asking which of these statements regarding sweep is or are correct. So two statements are correct. B is the right answer. Clear? Any questions as of now? Great. Let's look at question number 4. Which of the following statements regarding the high-level committee report on simultaneous elections? Remember the name of this committee? Shri Ram Nath Kovind Committee, former President of India, which was set up by the government to ensure or to provide for feasibility of holding simultaneous elections, what we call one nation, one election in India. Now, you don't have to mention, I'll give you a directive to this question. The question is asking on the report. What does the report say on simultaneous elections? Statement number 1, the constitutional amendments in relation to terms of parliament and state assemblies will not require ratification by states. However, constitutional amendments in relation to local bodies will be required to be passed with ratification by at least half of the states. The committee recommended holding elections for Lok Sabha and all state assemblies at the same time and that of local bodies within 100 days from them. Third, the committee recommended that a single electoral roll should be adopted. Which of these statements is or are correct? We have got 1 minute. Let me know what is the right answer. The correct answer is C. All the 3 statements are correct. Now let me explain. To hold one nation, one election, which basically means holding simultaneous elections to Lok Sabha as well as all the state legislative assemblies. For that we need a lot of constitutional amendments. Not just constitutional amendments, we need to amend Representation of the People Act as well. Not just that, we need to amend rules of business and procedure of Lok Sabha as well, Legislative Assembly as well. For example, rules concerning confidence motion, no confidence motion. We need to amend the constitution to provide for dissolution of the House. So some legislatures are to be prematurely dissolved. So lots and lots of constitutional amendments would be required. We also need a constitutional amendment to amend Article 356, which talks about the imposition of the president's rule in a state. But there are constitutional amendments which need to be ratified by at least half of the states as well. Whenever the Parliament wants to amend what we call the federal features of the Constitution. For example, if you want to change the manner and method of the election of the president, that's a federal feature. You need ratification by at least half of the states as well. If you want to change anything in the Schedule 7, if you want to change the power of the Supreme Court or the High Courts, if you want to alter Schedule 4 of the Constitution, if you want to change the executive power of the center of the states, all these are federal features. If you want to change Article 368 itself, that is a federal feature. And for that, a constitutional amendment bill ratified by at least half of the states is the requirement. This is a constitutional amendment bill. Let me see if you are clear with the basic concepts of a constitutional amendment bill. This is a bill. Bill is a proposal. The proposal is to amend the Constitution. This constitutional amendment bill can be introduced by a minister, by a private member as well. So this constitutional amendment bill can be a government bill, can be a private member's bill. It can be introduced either in Lok Sabha or Rajya Sabha, in either of the two houses of the Parliament. Prior recommendation or consent of the President is not necessary. And if it is introduced in one house, there it requires a special majority, which means 2/3 of the members present and voting plus majority of the total membership of the house, which means 2/3 of the members present and voting plus absolute majority. And once one house passes this bill, it is sent to another house. This another house, if it passes the bill by the same special majority, it is sent to the President for his signature, for her assent. And Constitution says, when a constitutional amendment bill is sent to the President for assent, she has to give her assent. She can't use any of the veto powers that are available. And this was done by amending the Constitution in 1971. 24th Constitutional Amendment Act 1971 made it mandatory, obligatory on part of the President to give assent to a constitutional amendment bill. She cannot withhold her assent, she cannot send the bill back, she cannot use the veto or the pocket veto. She has to give her assent to a constitutional amendment bill. But if this bill wants to change some of the federal features of the Constitution, before it can be sent to the President, it has to be sent to all the state legislatures, including the legislatures of union territories, those union territories which have a legislative assembly. And only when at least half of those state legislatures, they pass this constitutional amendment bill by passing a simple majority, by passing a resolution by simple majority, then it is sent to the President for her assent, and President has no other option but to give her assent to a constitutional amendment bill. Clear? A student asked a question yesterday. Sir, what about the Union Territory of Jammu and Kashmir? Can the MLAs belonging to the Union Territory of Jammu and Kashmir participate in the President's election? I do not have an answer to this question. Why? Because normally, to enable Union Territory MLAs to also participate in the election of the President of India, you require constitutional amendment, that too ratification by at least half of the states. That's when Puducherry MLAs were made part of the Electoral College, constitutional amendment was done. When Delhi MLAs were made part of the Electoral College, constitutional amendment was done. And that too with ratification by half of the states. Because if you change the manner or method of president's election, that is a federal feature, and that requires ratification by half of the states as well. But the Jammu and Kashmir Reorganization Act says whatever is true for Puducherry, that is true for Jammu and Kashmir as well. Since Puducherry MLAs are part of the Electoral College, which means J&K MLAs will also be part of the Electoral College. But this is an unclear territory. We have no answer to this question, because my sense is you need a constitutional amendment to include J&K MLAs if they want to participate in the election of the President of India. Clear? One such federal feature is Schedule 7, as I said. Who prepares the electoral roll when it comes to Panchayati Raj elections, when it comes to elections to urban local bodies? State Election Commission. So State Election Commission is also a constitutional body. Election Commission of India is also a constitutional body. But electoral rolls for Lok Sabha, Legislative Assembly elections are prepared by Election Commission of India. Electoral rolls for the urban local bodies, Panchayati Raj institutions, are prepared by State Election Commission. So if you want Election Commission to prepare electoral rolls for Panchayat and urban local body elections as well, that requires a constitutional amendment, that too ratification by half of the states, because that is a federal feature. That is why we say constitutional amendment in relation to the terms of the parliament and state assemblies will not require ratification by states, because it's not a federal feature. However, constitutional amendment in relation to local bodies will be required. This is correct. Why? Because entry 7 of state list number 2, state list, it talks about local bodies. And if you want any changes there, you require a constitutional amendment, that too ratification by half of the states. The committee recommended holding elections for Lok Sabha and all the state assemblies at the same time. This is correct. And that of local bodies as well, within 100 days from them. This statement is also correct. That is the recommendation of the Ramnath Kovind Committee on simultaneous elections. The committee recommended a single electoral roll should be adopted. This is also correct. That is why C, 3 statements are correct. But please understand, for this also, you need a constitutional amendment ratified by at least half of the states. Clear? That is question number 4. Very good. Let's look at question number 5. To implement electoral bond scheme, which of the following laws were amended? Representation of the People Act 1951, Representation of the People Act 1950, Reserve Bank of India 1934, Income Tax Act of 1961, Companies Act of 2013, Foreign Contribution Regulation Act FCRA 2010. Select the correct code from below. Tell me what is the right answer. One minute. What's the right answer? B, A, D, A. The correct option is B. Only 4 is the right answer, and 35% of the students are right. How? Electoral bond scheme, which started in 2017, and this year in a unanimous verdict, the Supreme Court, in Association for Democratic Reforms versus Union of India, declared that electoral bond scheme is unconstitutional. So you may not be asked questions about the electoral bonds as to what are these electoral bonds, who is eligible to purchase these electoral bonds, get funding from these electoral bonds, but maybe what laws were amended for implementing electoral bond scheme. Representation of the People Act 1951, was it amended? Yes. Why? Because under Representation of the People Act 1951, if I am donating money to a political party in excess of rupees 20,000, the political party has to disclose the identity of the donor. But when electoral bond scheme was launched, the whole objective of electoral bond scheme was on anonymity. That means the donor has to be anonymous. That means the Representation of the People Act was amended to say that you have to disclose the identity of all the donors who donated money to you in excess of 20,000, excluding the donations received by you through electoral bonds. Even if through electoral bonds somebody has donated in excess of 20,000, but we have to keep the identity of that donor anonymous. That is why this law was amended. Representation of the People Act 1950, no, this was not amended. Why? Because Representation of the People Act 1950, it speaks about the allocation of seats to Lok Sabha, to legislative assemblies, to legislative councils, delimitation, it talks about the qualification of the voter, it talks about the election officers who are responsible for the preparation of the electoral rolls. This law need not to have been amended. Reserve Bank of India, correct. Why? Because this law was amended to allow any scheduled bank the central government was empowered to nominate any scheduled bank to print these electoral bonds. And then the central government gave this responsibility to State Bank of India. Clear? Income Tax Act 1961, yes, it was also amended. Because Income Tax Act 1961, political parties, they don't have to pay tax, but they have to submit their income tax returns to the income tax authorities by September every year. And they have to disclose the identity of those donors who have donated money to them, except the money that you have received through electoral bonds. So this Income Tax Act was also amended. Companies Act was also amended. Why? Because previous to these electoral bonds, there was a limit that a company can donate 7.5% of the profit over the 3 years. That means only profit-making companies could have donated money to political parties. But now this limit was reduced. That means now loss-making companies could have also donated money to political parties. And this cap, this limit of donating only 7.5% of the profits over the past 3 years, this cap was removed. That means now you can donate any amount of money to political parties through electoral bonds. Foreign Contribution Regulation Act, this is where you might have made a mistake, but this law was not amended for electoral bonds. So that is why only 4B is the right answer. FCRA, we will have a detailed discussion of FCRA in the upcoming classes. But FCRA, specific to political parties donation, previously there was a limit that only the Indian companies can donate money to political parties. Foreign contribution was not available to political parties. That means you can't raise money from abroad for political parties. But then there was a controversy where two major political parties, the BJP and the Congress, they got donations from foreign companies as well. And then the Finance Act of 2016 was passed. And this Finance Act of 2016 amended FCRA, saying if there are Indian subsidiaries of foreign companies, they can donate money to political parties. So foreign companies cannot donate money to political parties, cannot contribute to political parties. But Indian subsidiaries of foreign companies can. But that was done by the Finance Act of 2016. An electoral bond scheme was announced in the Finance Act of 2017. So which of these electoral bond scheme which of these laws were amended for the implementation of electoral bonds? B, only 4 is the right answer. Clear? Okay. You may also be asked, which of the following electoral reforms have been implemented in India on the directions of the Supreme Court? Or which of the following electoral reforms have been in place in India due to various judicial pronouncements? Can you name some of these electoral reforms which have been implemented in India because of the Supreme Court, because of judiciary? Anyone? Let me check what are the students saying. Okay. Nota. None of the above. In 2013, VVPAT, Voter Verifiable Paper Audit Trail. Similarly, Lily Thomas versus Union of India, again in 2013. And it said Section 8, Clause 4 of the Representation of the People Act 1951 is unconstitutional. What was this Section 8, Clause 4 of the Representation of the People Act? For example, if I am a legislator, I have been convicted by a court for a term of 2 years or more, I am not disqualified. Instead, 3 months were provided to me. I can appeal before the High Court. If High Court also says you are guilty and you are sentenced to imprisonment of 2 years or above, even then I was not disqualified, because I could approach the Supreme Court. And only when the Supreme Court says you are guilty, then I would be disqualified. That means as a legislator, I am convicted for a crime, but I am not disqualified. I can still continue as a legislator. But here, if I am not a legislator, I am a normal person, I am your teacher, and I have been convicted by a court of law and sentenced to 2 years or more in jail, I cannot contest elections. So you are violating Article 14, the right to equality. So you are creating a distinction between a legislator and an ordinary citizen. And this distinction is arbitrary, manifestly arbitrary, which violates Article 14 of the Constitution, because Article 14 says arbitrariness also cannot be allowed. And Supreme Court said this Section 8, Clause 4 is unconstitutional. Now, on the date of your conviction, if you have been convicted by a court of law and sentenced to 2 or more years in jail, on the date of your conviction, you are disqualified. Clear? Unless and until the higher court can suspend your sentence. This is what happened with Shri Rahul Gandhi when he was sentenced to 2 years in jail for defamation. But then this sentence was set aside, or this conviction was set aside, because that matter is under appeal. Similarly, asking the political parties that if you are giving tickets to candidates with criminal past, disclose why, that too in a newspaper. So if a political party is giving a ticket to a candidate who has a criminal past, it has to mention, it has to display in 2 prominent newspapers and give reasons to the people why I am giving ticket to this candidate with a criminal past. And by mentioning the reason, you don't have to mention winnability. Don't mention that because we think that this person can win the election, that is why we are giving tickets to him. No. Apart from that, what is the reason? That you have to disclose. Similarly, if you are submitting your nomination papers, you have to fill every column, every item in the nomination papers. You can't leave anything blank. And if you leave anything blank, the returning officer has been empowered to reject your nomination papers. Similarly, voters' right to know under Article 19, Clause 1, Clause A. This is where you'll have to link it. Because who petitioned the Supreme Court challenging the constitutional validity of electoral bonds? One big NGO was ADR, Association for Democratic Reforms. And the same association petitioned the Supreme Court many years ago saying we have the right to know the candidates. So publishing educational qualification of the candidates, what is the amount of assets in your name and in the name of your spouse, how many criminal cases are pending against you, all this information a candidate has to publish, has to reveal, because that is how you and me, the voters, can make an informed choice whether we want to vote for this candidate or not. All these have been some of these electoral reforms which have been implemented in India thanks to the Honorable Supreme Court. Clear? Very good. Let's look at question number 6. If electoral bonds are in the news, there is another way in which political parties receive donation from corporates, and that is what we call electoral trusts. So now the question is electoral trust. Consider the following statements. Statement number 1, an electoral trust is a trust set up by companies with the only objective of distributing the contributions received by it from other companies and individuals to political parties. The electoral trusts are permitted to set aside a maximum of 20% of the total funds collected during a financial year for administrative purposes. All non-resident Indians are ineligible to donate to the electoral trusts. An electoral trust cannot accept cash donations. Which of the above statements is or are correct? You have 1 minute. Let me know what is the right answer. Let's have a poll. One minute. Let me know what is the right answer. Question number 6, the correct answer is B. Electoral trust is a trust set up by the companies, but only those companies which are registered under the Companies Act of 1956. And the only objective of setting up this electoral trust is to receive donations so that we can contribute to political parties. That is an electoral trust. So every company which is registered under Companies Act of 1956 can set up an electoral trust. This statement is correct. The electoral trusts are permitted to set aside a maximum of 20%. No. Maximum of 5%. That means if an electoral trust is receiving donation, 95% of that donation they have to contribute to political parties. Remaining 5% they can spend for administrative purpose, for example the rent, salaries, other expenses. So this statement is incorrect. All non-resident Indians are ineligible to donate to the electoral trusts. Correct, incorrect? Correct or incorrect? Weber is saying under FCRA it was 20%. Yes, that is why I have mentioned, so that I can confuse you between FCRA and electoral trusts. Correct or incorrect? All non-resident Indians are ineligible to donate to the electoral trust. This is incorrect. Why? Because some NRIs are eligible. And who are these non-resident Indians who are eligible? Those who have passport number. All those NRIs with passport number, they're eligible to donate through electoral trusts. But those who are not, who don't have a passport number, they're not. That is why the qualifier. All non-resident Indians, no. An electoral trust cannot accept cash donations. This is correct, because they have to accept donations in the form of check, in the form of demand draft, or through electronic means. Question number 6, B is the right answer. Clear? Done. Let's look at question number 7. Consider the following statements. The 2019 general elections was the first where EVMs were 100% backed by the VVPAT machines. VVPAT slips of 5 randomly selected assembly constituencies or segments are counted to verify with the count of the EVMs. The Supreme Court, in its recent judgment, has directed the Election Commission of India to count VVPAT slips using a counting machine rather than by humans. Let me know what is the right answer. You have 1 minute. Question number 7, 1 minute. What's the right answer? Disclose the answer. Yes, why not? Question number 7, the answer is B. 2019 general elections was the first where EVMs were 100% backed by the VVPAT machines. This is correct. VVPAT was introduced because of the judgment of the Supreme Court in Subramaniam Swamy. Why? Because there was an issue in terms of transparency. If I press the button on the electronic voting machine, the vote is registered. But how do I know whether the vote is indeed registered for the party of my choice, for the candidate of my choice or not? For that, a paper trail is necessary, said the Supreme Court in Subramaniam Swamy case. VVPAT was first introduced on an experimental basis in 2013 in Noksen constituency of Nagaland. But then 2019 was the first election where all EVMs were backed by VVPAT machines. And in VVPAT, what do you get? You press the button on the electronic voting machine, a screen is displayed. Listen to me carefully, these facts are important. What is displayed on the VVPAT screen? The serial number of your vote, the name of the candidate against whom your vote has been registered, and the symbol of that political party. And all this information is displayed for how many minutes? 7 seconds. After that, this paper trail is cut, it drops in the box. Now, there was a petition filed in the Supreme Court. What was the petition? Not this time, previously. What was that petition? What Election Commission of India was doing, for example, this is a parliamentary constituency. Parliamentary constituency is a bigger constituency consisting of smaller assembly constituencies as well. So one parliamentary constituency has many assembly constituencies. What Election Commission of India will do, From one assembly constituency, it will pick one EVM and match it with VVPAT. That means one assembly constituency in a parliamentary constituency, pick one EVM and match the EVM count with the VVPAT. That's it. N. Chandrababu Naidu from Andhra Pradesh approached the Supreme Court and said this number should be increased. And Supreme Court directed that instead of one EVM, what you should do, you should verify 5 EVMs per assembly constituency, per assembly segment in a parliamentary constituency. Now a petition was filed in the Supreme Court saying this number should be 100%. That means all VVPAT slips should be matched with the EVMs. Some said it should be 25%, some said it should be 50%. Supreme Court rejected this petition saying don't confuse the voters, don't unnecessarily doubt the system. We are satisfied with what Election Commission has said. We are satisfied with the way VVPATs are being handled. So this situation will remain. Now ECI will do the same thing. Verify 5 EVMs randomly per assembly constituency in a parliamentary constituency. But then what has changed because of this judgment? Has anything changed because of this judgment? Can anybody tell me? What has changed? Has anything changed or no? Sikandar Karan, I'll clear your confusion. What is 5 and 5%? Has anything changed? No. Okay. Something has changed. And what has changed? Number 1, candidates, and listen to me carefully. Candidates who come second or third. Results have been declared, and within 5 to 7 days, the candidates who came second or third, they can ask for verification. Verification of 5% EVMs with VVPAT. That has changed. So after the election, a candidate who came second or third can ask for re-verification of 5% EVMs per assembly constituency in a parliamentary constituency. Not 5%, but that too only after the election. But this candidate will have to bear the expense. The candidate has to bear all the expenses. And if there was a mismatch, if there was an error, if there was some kind of illegal thing, then this expense will be reimbursed, will be refunded back to this candidate. This is change number 1. Something else has also changed. SLU. What is this SLU? Anybody? Symbols loading unit. VVPAT is like a printer. So when you press the button on the electronic voting machine, the name, the serial number, the symbol is displayed on the screen, and then it gets printed and cut and dropped into the box. But you have to use something to load symbols on the VVPAT machine. Otherwise, how would it recognize what to print? This symbols loading unit will have to remain like this for 45 days after the declaration of results. So the symbols loading unit, which is used to load symbols on the VVPAT machines, which then get printed, this has to be stored for 45 days after the declaration of results, so that in any case there is a petition, we can have a look at these symbols loading unit. Clear? Let's go back to the question. The 2019 general election was the first where EVMs were 100% backed by VVPAT machines, correct? VVPAT slips of 5 randomly selected assembly constituencies or segments are counted to verify with the count of the EVMs. This is also correct. The Supreme Court in its recent judgment has directed Election Commission to count VVPAT slips using a counting machine rather than by humans. This is incorrect. Yes, Supreme Court did talk about this matter, but Supreme Court did not direct. It basically advised the Election Commission that if you want, you can consider. What is this consideration? Supreme Court said maybe for every VVPAT machine, there can be a barcode so that this barcode through a machine is counted, is used for counting rather than you manually counting these VVPAT slips. But since the Supreme Court said, since this is a technical matter, it involves technical expertise, you should consider this. But we are not directing you to count these VVPAT slips using a counting machine and not by the humans. No, this is incorrect. That is why 1 and 2, B is the right answer. Clear? Okay. Question number 8. The term res judicata, often seen in the news, means A, a hearing or a trial which is conducted in the absence of one party. B, criminal intent required to convict a person. C, an action of a judge to withdraw himself from a case in which his bias to one of the parties may be called into question. D, a concept which bars parties from relitigating issues that have been conclusively settled. Let me know what is the right answer. Res judicata. Majority says C. C. Devesh is saying C. It's a very easy question. Devesh, C is wrong. Okay. A hearing or a trial conducted in absence of one party. The term used for this is ex parte. When the judgment is given ex parte without the presence of the other party. A criminal intent required to convict a person, the term used for this is mens rea. What is the intention? Is there a criminal intention behind? And that is very important in criminal cases. An action of a judge to withdraw himself from a case in which his bias to one of the parties may be called into question. The term that we use normally for this is the recusal. The judge has recused from a particular case because the petitioner is alleging bias, violation of principles of natural justice, so on and so forth. A concept which bars parties from relitigating issues that have been conclusively settled, because once a judgment is given on an issue, others cannot randomly come and reopen the same case or file a case on the same issue again and again. That is what we call res judicata, a concept which bars parties from relitigating on issues that have been conclusively settled. Clear? Great. What is this principles of natural justice? Listen to me carefully. There are 3 principles of natural justice. Number 1, no one can be the judge in his own case. No one shall be punished without being heard and the third one is the authority shall act bona fide, which means in good faith, which means the intention of the executive when it is making rules, the intention of the legislature when it is making laws, it has to be good for the larger benefit of the society. It cannot be with a bad intention. This is what we call principles of natural justice. And Supreme Court in multiple cases have said this principles of natural justice is an integral part of the Constitution. It is found in Article 14 of the Constitution. Clear? Okay. Let's look at question number 9. Which of the following statement is incorrect? Political parties can release election manifestos when model code of conduct is in place. No FIR can be filed against anyone for violating the provisions of the model code of conduct. Political parties need to disclose the source of funds for fulfilling promises made in their election manifestos. D, all of the above. What is the right answer? Authority can be legislature, authority can be executive, authority can be judiciary. Again, Ankit is saying B, very easy, which means this B is not a right answer. Okay. Political parties can release election manifestos when model code of conduct is in place. Yes, they can. Election manifestos can be released by political parties even when model code of conduct is in place. But there is a limitation. Is there any limitation? They cannot release election manifestos during the period of election silence. What is this election silence period? For example, the voting takes place or the voting ends on Monday, 6 o'clock in the evening. Monday, 6 o'clock, the voting ends. From that time, calculate 48 hours behind. That period is known as the period of election silence. During this period, no campaigning can take place, no canvassing for votes can take place, so that the voters can independently decide which political party or candidate to vote for. During this period of election silence, even election manifestos cannot be released. But can election manifestos be released by political parties during model code of conduct? Yes. So this is correct. This is not incorrect. The question is asking which is the incorrect. No FIR can be filed against anyone for violating provisions of model code of conduct. Correct. Now listen to me carefully. Model code of conduct, there is no statutory backing. Statutory backing in the sense there is no law which provides for a model code of conduct. The political parties, they have voluntarily decided to come together and create this document called Model Code of Conduct, which they believe is a moral code of conduct, which they have said we will adhere to, we will abide by this Model Code of Conduct. But there is no law which backs this Model Code of Conduct. There is no law. But there are some provisions of Model Code of Conduct which are similar provisions in Indian Penal Code, which are similar provisions in the Representation of the People Act 1951. For example, can you bribe voters? No, because that is violation of Indian Penal Code, that's bribery. But that's also violation of Model Code of Conduct. So if somebody is bribing the voters, yes, FIR can be filed against that person, but not for violating Model Code of Conduct, but for violating Indian Penal Code, which is a law. Similarly, for example, if you are creating enmity amongst different sections of the society. If I'm giving a speech which creates a wedge between different society in the name of religion, in the name of caste, in the name of race, in the name of language, is that a violation of model code of conduct? Yes, it is. Because political parties have said we will not create enmity on the grounds of religion, race, caste, language, or any of them. But that's also a violation of the Representation of the People Act 1951. So if somebody is creating enmity amongst different sections of the society, for that FIR can be filed, but not for violating Model Code of Conduct, but for violating a Representation of the People Act, because Model Code of Conduct does not enjoy statutory backing. So no FIR can be filed against anyone for violating the provisions of Model Code of Conduct, correct? But FIR can be filed for violating those provisions of Model Code of Conduct which are also provisions under different laws. For example, Indian Penal Code, for example, the Representation of the People Act. That's why the statement is correct. Political parties need to disclose the source of funds for fulfilling promises made in their election manifestos. This is incorrect, so C is the right answer. How? Supreme Court in Subramaniam Balaji. This time it's not Subramaniam Swami. Subramaniam Balaji. The question was election manifestos. The question was on freebies. What Mr. Modi calls ravedies. For example, DMK, a political party in Tamil Nadu, it asked people that you vote for us, and in our election manifesto we have mentioned that we will give you juicer, mixer, grinder, we will give you color television sets. This was in 2007, and in 2011 AIADMK said if you vote for us, we are mentioning in the election manifestos that we will give you a cattle, buffalo, we will give you a gold ring, we will give you something else as well. So freebies are given. Now Subramaniam Balaji approached the Supreme Court saying these election manifestos and the promises made in these election manifestos, this is like a corrupt practice. Under section 123 clause 3 of the Representation of the People Act 1951, it's like you're bribing the voters. Vote for me, I will give you juicer, mixer, grinder, gold ring, buffalo, color television sets. Supreme Court said, yes, these election manifestos, they can have the potential of shaking the root of free and fair elections. But Supreme Court said these election manifestos are not corrupt practice within the meaning of Representation of the People Act 1951. But it did ask Election Commission of India that you can consult political parties and try and find out a way in which political parties create these election manifestos, and maybe ask these political parties that if these are the promises that you have made, you should also tell us what is the source of funds, from where will you get the money to implement this election manifesto. But political parties, they met Election Commission, but no action on this could be taken. In fact, this is a sub judice matter. That means this matter is still with the court. The court has now to decide whether we can direct political parties that whatever you are promising in your election manifestos, you also tell us what is the source of funds. From where will you get the money to implement these promises that you have made in the election manifestos? But political parties need to disclose the source of funds for fulfilling promises made in their election manifestos. This is incorrect because this matter is sub judice, which means this matter is pending before the court. Clear? Okay. Let's look at question number 10. Which of the following statements is or are correct? The Convention on the Elimination of All Forms of Discrimination against Women provides that discrimination against women must be eliminated in political as well as public life. India is a signatory to the above convention. Women's reservation provided by the 106th Constitutional Amendment Act shall cease to have effect on the expiration of a period of 15 years from the commencement of the Act. the government by a notification can extend the validity of the reservation. Let me know what is the right answer. What is the right answer? Ashutosh says quite simple. B is the right answer. Which means not every day is a Sunday. This time B is the right answer. The Convention on the Elimination of all forms of discrimination against women provides that discrimination against women must be eliminated in political as well as public life. This is correct. And this convention was adopted by United Nations General Assembly in 1979. India is a signatory to above convention. This is also correct. In fact, India has also ratified this convention in the year 1993. Women's reservation will cease to have an effect on the expiration of a period of 15 years from the commencement of the Constitution. What is this term called? A law which has an expiry date, that after 15 years it will cease to exist, or after 10 years it will cease to exist. What is that term called? Yes, Vaibhav is right. Sunset clause. So yes, this law has a sunset clause. That means after 15 years it will cease to exist, but it can be extended. But not by the government notification, but it can be extended by the law passed by the parliament. That is why statement 3 is incorrect. 2 is the right answer. Clear? 106th Constitutional Amendment Act. It is also 128th Constitutional Amendment Bill. Just for the sake of information, maybe the question is asked on 128th Constitutional Amendment Bill, and you will be confused that we only have had 106 amendments, and what is this bill all about? So this is about women's reservation. Through this Reservation Act, the parliament said seats in Lok Sabha, Legislative Assembly, and the National Capital Territory of Delhi, there the seats shall be reserved. 1/3 of the seats, not less than 1/3 of the seats shall be reserved for women. But then a separate law was passed to extend this women's reservation for Puducherry as well, for Jammu and Kashmir as well, because these are the other two union territories with legislative assembly. Although right now there is no assembly in J&K, but there can be a legislative assembly in J&K. Clear? But listen to me carefully. Was this 128th Constitutional Amendment Bill ratified by at least half of the states? Yes or no? Was it ratified by at least half of the states? Rahul says yes. Others are saying no. No. But why? Because it does not alter Schedule 4. It does not talk about the representation of states in the Rajya Sabha. If it would have altered representation of seats in Rajya Sabha, then it required constitutional amendment, that too ratification by at least half of the states. That is why it did not require this constitutional amendment. Plus, When will this women's reservation come into picture? When will it be implemented? This can be implemented only after delimitation, which can happen only after census. But the census, which was supposed to be carried out in 2021, has been postponed. Why? Because of the COVID-19 pandemic. Maybe after the new government comes to power, we will have census. Once that census is carried out, then we will have delimitation. And once that delimitation is carried out, then Women's Reservation Act will be implemented. Clear? Yes. But what is this delimitation? Once the population increases, corresponding to that increase in population, there should be increase in the number of seats as well, number of elected representatives as well. That's what we call delimitation, which means delimitation is what? Redrawal of electoral constituencies. Clear? This happened in 1951, this happened in 1963, this happened in 1973 as well, which means after the census of 51, after the census of 61, after the census of 71, delimitation was carried out. But as delimitation was carried out, we saw increase in the number of seats based on the increase in the population in the northern states. Not much in the southern states, because southern states had effectively implemented family planning programs. This is where the southern states approached the government, and the parliament enacted 42nd Constitutional Amendment Act 1976, saying no more delimitation till the year 2001. Then delimitation was again carried out after the census of 2001, and the final award of this delimitation was given in 2008. But now further there can be no delimitation till 2026, and the seats will also be frozen. That means the seats got increased in 51, 63, 73, but after that delimitation was carried out in 2001. The final award was given in 2008, but it did not lead to increase in the number of seats, because the number of seats will remain frozen till 2026. And now no delimitation can be carried out till 2026, which means if at all delimitation can be carried out in 2031 maybe. Or it can be carried out if the census is carried out in 2024, then delimitation can be carried out in 2025, after 2026, which means the earliest we can see Women's Reservation Act to be implemented is 2029. Clear? This is about delimitation. But listen to me carefully. Two things. The final award given by Delimitation Commission cannot be challenged in any court of law. Is this correct or incorrect? If this is correct, then why was the Delimitation Commission's case regarding Jammu and Kashmir heard by the Supreme Court? And why was delimitation carried out in Jammu and Kashmir? That can also be an important statement. Can anybody tell me in the comment section? Okay. When delimitation was carried out in the year 2008, when the delimitation award was given in 2008, there were few states which were excluded. States such as Assam, states such as Meghalaya, states such as Manipur, states such as Nagaland, states such as Jammu and Kashmir. But why these 4 states were excluded? Because they approached the court, they approached the government that don't make Census 2001 as the basis for delimitation. Why? Because there is according to them, lot of illegal migration which has taken place. So don't make 2001 census as the basis for delimitation. And ultimately what happened? They approached the Guwahati High Court, and then the President of India issued a notification saying we will not conduct delimitation in these 4 states. And when next time delimitation will be conducted, it will be conducted by the Election Commission of India. Which means, listen to me carefully, if tomorrow there is a statement in your examination which says in India delimitation can be carried out only by Delimitation Commission, that statement is incorrect. Because in India, delimitation can also be carried out by Election Commission of India. Because for these 4 states, whenever delimitation is carried out, will be carried out by Election Commission. And Election Commission is carrying out delimitation in Assam. But for J&K, since they had a different special status under Article 370, that is why in 2002, delimitation was not carried out in J&K. But now J&K, since it was converted into a union territory, delimitation was carried out. In fact, a 3-member delimitation commission was set up, headed by former Supreme Court Judge Justice Ranjana Desai. Because who is going to be the head of this delimitation commission? Either retired or serving judge of the Supreme Court is going to be the chairperson of this Delimitation Commission. And this was challenged in the court. But now if you're saying, sir, under Article 329, there is a bar in the interference of courts in electoral matters. One such electoral matter is delimitation, which means the award given by the Delimitation Commission cannot be challenged in any court of law. Then why was it challenged in J&K? The award was not challenged. The process of delimitation was challenged, saying if there can be no delimitation in the entire country till 2026, why should there be delimitation in Jammu and Kashmir? If there can be no increase in the number of seats anywhere in the country, in any legislative assembly, in Lok Sabha, why should there be an increase in the 6 seats for Jammu and Kashmir Legislative Assembly? The Supreme Court rejected this petition, saying Jammu and Kashmir is not a state, it's a union territory. So for union territory, there can be delimitation and there can be an increase in the number of seats. So the award was not challenged. The very process was challenged. And who can carry out delimitation? It can be carried out by Delimitation Commission. It can also be carried out by the Election Commission of India. Clear? So this is question number 10. Which of the following statements is or are correct? B is the right answer. Now let's take a look at question number 11. Which of the following statements regarding the Press and Registration of Periodicals Act 2023 is or are correct? Let me know what is the right answer. The Act does not cover books and journals for the purpose of registration. All applications for registration of periodicals shall be made in online mode through the Press Seva portal only. A person who has been convicted by any court for an offence involving terrorist act or unlawful activity can bring out a periodical only after he has completed the jail term. There is no jail term prescribed for those violating the law. Let me know what is the right answer. If it's a bouncer, hit it, duck it, but do something. What is the right answer? Question number 11. B is the right answer. This is a Press and Registration of Periodicals Act 2023, which talks about registration of newspapers, registration of periodicals. For example, those periodicals which are released every period, which can be daily, which can be weekly, which can be fortnightly. But it does not cover books and journals for the purpose of registration. Why? Because we have a separate procedure for the registration of books, which comes under Raja Ram Mohan Roy International System for Book Numbers. That's a different thing. All applications for registration of periodicals shall be made in online mode through Press Seva portal only. This is also correct. A person who has been convicted by any court for an offence involving terrorist act or unlawful activity can bring about a periodical only after he has completed the jail term. It's incorrect. The law says those who have been convicted for unlawful activity or terrorist act, they are not permitted to bring out a periodical. So it has got nothing to do with whether jail term you are serving or you are coming back from the jail term. No, this is false. There is no jail term prescribed for those violating the law. There is a jail term. What is the jail term? For example, if I have to publish a newspaper or a periodical, clear? I have to register. If without registration I am publishing a periodical, notice will be sent to me, fine will be imposed on me, and I have to stop publication of this periodical. What if I got the notice today and for 6 months I am not stopping the publishing of this periodical? After that, I can be given a jail term. I can be convicted. And this jail term can be up to 6 months. Or fine as well. Or both. So there is no jail term prescribed for those violating the law. This is incorrect. B is the right answer. Something else. What is this facsimile? Facsimile. Anyone? Vaibhav Raj, international journal, copy of international. For example, there is an international journal, and in India, you want to publish the replica of that international journal. That's what we call facsimile. This cannot be published without the consent of the central government. So the question can be asked, facsimile can be published on the directions or after the approval by the state government. That statement is incorrect, because with the consent of the central government, facsimile can be published. Clear? And through this law, a very old law, Press and Registration of Books Act of 1867, this was repealed. So this law, Press and Registration of Periodicals Act 2023, this replaced the 1867 law, which is Press and Registration of Books Act 1861. So which of these statements are correct? Two statements are correct. B is the right answer. Any questions as of now? I think the time is up. We have crossed 9 p.m. Every day we will have these classes from 7:30 p.m. to 9 p.m. So 90 minutes of classes where we will discuss MCQs as well as elaborate explanation of those MCQs and the concepts related to them. And if this session has been of some help to you, do let me know in the comment section after the live stream is over. Do not forget to press the like button and subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. I'll see you again tomorrow, 7:30 p.m. in the evening with Lecture 2 of Conquered Prelims 2024. But if you have got any questions, please let me know. for another 5 minutes, I'll be taking your questions. Election Commission is conducting delimitation in Assam. The PDF will be available after the class. Will the reservation for women implemented in all states, or the states will have to pass their law in their respective assembly? No, the same law will be applicable. A statutory body is a body which is created by the law passed by the parliament. For example, National Human Rights Commission, National Commission for Women. A constitutional body is a body which is created by the constitution itself. For example, Election Commission of India, Union Public Service Commission, Finance Commission. UCAN would be included in Manzil course. If you have enrolled in the course, UCAN is part of it. Hari Om, congratulations. Can governor pardon a death sentence? No, the governor can only commute a death sentence. Okay, that is it for today. See you tomorrow, 7:30 p.m. in the evening. Till then, have a great time. All the best. Good night.